Good afternoon, friends. You are most welcome to Civil Affairs. Today, we are going to discuss Vision IAS updated classroom study material from January 2024 to March 2024. Here, we are going to prepare UPPSC UPSC prelims 2024, and our topic is Minority Educational Institution MEIS under the topic of Polity. Why in the news? A constitution bench of the Supreme Court has reserved judgment on the case concerning the minority status of the Aligarh Muslim University AMU about the Minority Educational Institution MEIs. Article 30 Clause 1 of the Constitution deals with the rights of linguistic and religious minorities' rights to establish and administer educational institution of their choice. National Commission for Minority Educational Institution Act NCMEIA 2004 was enacted to safeguard educational rights of the minority enshrined in Article 30 Clause 1. The Commission, a quasi-judicial body and possesses power of a civil court, decide questions relating to the status of any institution as the Minority Education Institution MEI. Central government has notified 6 religious minority communities with Muslim, Christian, Sikh, Buddhist, Parsi and Jain. However, minorities communities is not defined in the constitution. A special privilege enjoyed by minority education institution under Article 30 1A 30 Clause 1A. Under Article 30 Clause 1A, in case of acquisition of any property of an educational institution established and administered by a minority, due compensation to be provided. MEI minority education institutions are not required to implement the reservation policy under Section 3 of the Central Educational Institution Reservation in Admission Act 2006 as amended in 2012. Right to Education Act 2009 is not applicable to minority educational institution MEIs, aided or unaided. Whatever. Functioning of Parliament, State Legislature or local government. Panel of Vice Chairpersons in Rajya Sabha. Vice President and Rajya Sabha Chairman reconstituted the panel of Vice Chairpersons. Chairman constitutes panel of Vice Chairpersons under Rule 8 of the Rules of Procedure and Conduct of Business in the Council of States, that is Rajya Sabha. These rules are framed under Article 118 of the Constitution. Any of the members of panel may preside over Rajya Sabha in absence of chairman and deputy chairman. They hold office until a new panel is nominated. When office of both chairman and deputy chairman are vacant, duties of office of chairman are performed by such members of Rajya Sabha as president may appoint. Motion of thanks. Prime Minister replied the motion of thanks on President's address. About motion of thanks, it is formal motion moved in the House expressing its gratitude to the President for the address delivered by him or her under Article 87 Clause 1 of the Constitution. Article 87 of the Constitution requires the President to address both houses of the Parliament assembled together and inform Parliament of the causes of its summons at the commencement of the first session after general election of the House of the People and the first session of each year. It must be adopted in both the houses of the parliament. It can be adopted with amendments. Minister without portfolio. Madras High Court questioned Tamil Nadu state government about continuation of an accused as minister without portfolio. About minister without portfolio, Government of India allocation of business rules 1961 allows president on advice of Prime Minister to entrust responsibilities of specified businesses to a union minister without portfolio, do not have a department or office to handle but entitled to prerequisites and privileges of a minister, does not draw salary and emoluments as minister but only as a member of legislature. Denotification of cantonments. The Ministry of Defence MOD denotifies civil areas of 10 cantonments which will be merged with concerned state local bodies. Earlier in 2023, Ministry of Defence has notified the state governments to consider merging civil areas of cantonments with neighboring state municipalities. Military areas of the cantonment will be declared as military stations under the complete control of the army. About cantonment, an area where military troops are garrisoned and is primarily dedicated to the housing soldiers. However, civilian population are also present. Genesis established by East India Company after the Battle of Plassey in 1757. Barakpur, Calcutta was the first cantonment established in 1965. Barakpur, Calcutta was the first cantonment established in 1965. Currently, there are 62 cantonments in India. Administration, local self-government of the cantonments is the subject matter of the Union Government, entry 3 of the Union List. Next topic is Judiciary, 75 years of the Supreme Court of India. Why in the news? Recently, the Prime Minister inaugurated the Diamond Jubilee celebration of the Supreme Court of India on 28 January at the Supreme Court Auditorium in Delhi. More in news. On the occasion, Prime Minister launched multiple technology initiatives for the Supreme Court. Digital Supreme Court reports it will make Supreme Court judgments available to the citizens of the country free of cost and in electronic format. Digital Courts 2.0 application is a recent initiative under the e-courts project to make courts records available to the judges of the district courts in electronic form. The e-courts mission, launched in 2013, aims to modernize India's court system by making it digital and improving access to justice. About Supreme Court of India, according to Article 124, Clause 1 of the Indian Constitution, the Supreme Court of India must have a Chief Justice of India (CJI) and the maximum 7 additional judges unless Parliament specifies a higher number through a statute. Currently, the sanctioned strength of the Supreme Court is 34, including the Chief Justice of India. Constitutional provision, the Supreme Court's power and jurisdiction are outlined in Article 124 to Article 147 of the Indian Constitution. Key features of the Supreme Court of India: original and exclusive jurisdiction to adjudicate federal disputes under Article 131. Original and exclusive jurisdiction to adjudicate federal disputes under Article 131. Original jurisdiction for enforcement of fundamental rights under Article 32. Very wide appellate jurisdiction over all courts and tribunals in India. Very wide appellate jurisdiction over all courts and tribunals in India, as it may in its discretion grant special leave to appeal under Article 136. Very wide appellate jurisdiction over all courts and tribunals in India, as it may in its discretion grant special leave to appeal under Article 136. Advisory jurisdiction under Article 143. Power to review any judgment or order made by under Article 137. Related news. Regional benches of the Supreme Court, Parliamentary Standing Committee on Personal Public Grievances, Law and Justice informed the Parliament about the government's acceptance of its recommendation to establish regional benches of the Supreme Court. Supreme Court of India may invoke Article 130 of the Constitution to establish its regional benches. As per the Article 130 of the Constitution of India, the Supreme Court shall sit in Delhi or such other places or place as the Chief Justice of India may, with the approval of the President, from time to time appoint. Tribunal system in India, our next topic. Why in news? Recently, the Supreme Court ruled that tribunals cannot direct the government to frame policy. More in news. Supreme Court was deciding on whether the Armed Forces Tribunal (AFT) could have directed the government to make policy to fill up the post of Judge Advocate General (AIR), Judge Advocate General all over India. The AFT Armed Forces Tribunal was set up under the AFT Armed Forces Tribunal Act of 2007. AFT Armed Forces Tribunal provide the adjudication or trial of disputes and complaints to the Commission, appointments, enrollment and condition of service in respect of persons subject to the Army Act 1950, Air Force Act 1950, Navy Act 1957. It can further provide for appeals arising out of orders, finding, or sentences of courts martial held under the said acts and for matters connected therewith or incidental thereto. Armed Forces Tribunal AFT has a power of civil court. Supreme Court held that as tribunal subject to the High Court jurisdiction under Article 226 cannot be permitted by the law to direct the framing of a policy by the government. Also, the Supreme Court said that making policy is not in the domain of the judiciary. About tribunal system nature, tribunals are quasi-judicial bodies. The objective may be to reduce the caseload of the judiciary or to bring in subject expertise for technical matters. Constitutional recognition in 1976, Article 323A and Article 323B, capital A and capital B here. Article 323A and Article 323B were inserted in the Constitution of India through 42nd Amendment of the Constitution, that is the mini constitution. Article 323 capital A empowered Parliament to constitute administrative tribunals both at central and state level for adjudication of matters related to recruitment and condition of service of public servants. Article 323B specified certain subjects such as taxation and law and land reforms, taxation laws and land reforms, etc., for which Parliament or state legislature may constitute tribunals. In 2010, the Supreme Court clarified that subject matters under Article 323B are not exclusive and legislature are empowered to create tribunals on any subject matter under their purview as specified in 7th schedule of the Constitution. Composition of the tribunals, the presence of expert members, technical members, along with judicial members, is a key feature of tribunals which distinguishes them from traditional courts. Jurisdiction, each tribunal is given a specific jurisdiction to hear and decide cases within its designated area of expertise. Some tribunals have appellate jurisdiction, meaning they hear appeals from decisions made by lower authorities or government bodies. Appeals from tribunals usually lie with the concerned high courts. However, some laws especially specify that appeals will be heard by the Supreme Court. In L. Chandra Kumar case 1997, appeals against decision of the tribunals were allowed in the division bench of the high courts. Key developments in the Indian tribunal system. 1941, Income Tax Appellate Tribunal was established as first tribunal in India. 1976, Swan Singh Committee 1976 noted that high courts were burdened with the service cases by public servants, and 42nd Amendment to the Constitution was passed. Article 323A and Article 323B inserted. Since 1980s, several tribunals were established under different acts. These include Central Administrative Tribunals for administrative matters, Securities Appellate Tribunals to hear appeals against decisions of financial sector regulators, etc. 2017, Finance Act 2017 reorganized the tribunal system by merging tribunals based on functional similarity. The number of tribunals was reduced from 26 to 19. It delegated powers to the central government to make rules to provide for the qualification, appointments, removal, and condition of service for the chairpersons and members of these tribunals. 2021, Tribunal Reforms Act 2021 was enacted. Act abolished certain tribunals like film certification, appellate tribunals, intellectual properties, appellate board, etc., and transfer their functions to existing judicial bodies, mainly high courts. Act also proposed changes in the process of appointment of the certain tribunals. Our next topic is defamation. Judicial pronouncement related to defamation. Subramaniam Swamy vs. Union of India 2016. Subramaniam Swamy vs. Union of India 2016. Supreme Court upheld Section 499 to be constitutionally valid. Chaman Lal vs. State of Punjab 1970. Supreme Court established the criteria for providing good faith and bona fide in defamation cases. Why in the news? 285th report of the Law Commission recommended that criminal defamation should be retained as part of the new criminal laws. More on news. It highlighted that the reputation flows from Article 21 and being a facet of right to life and personal liberty, it needs to be adequately protected against defamatory speech and imputations. Defamation is considered a reasonable restriction under Article 19, Clause 2 to the freedom of speech and expression in Article 19, Clause 1, Subclause A. Defamation is any false statement published or spoken deliberately, intentionally, knowingly, with, with the intention to damage someone's reputation. In India, defamation is categorized as either criminal or civil. Under criminal defamation, individuals can charged with an offense punishable by imprisonment or a fine. Civil defamation, on the other hand, involves filing a lawsuit seeking compensation for damages caused by defamatory statements. Constitutional and legal provisions for criminal defamation, Indian Penal Code IPC 1860 has comprehensive provisions pertaining to criminal defamation from section 499 to 502. Section 499 deals with overall definition of defamation. Section 500 deals with the punishment up to 2 years imprisonment or fine or both. The Bharati Nyaya Sanhita BNH 2023 had community service as punishment as well. Next topic is remission. Why news Supreme Court set aside remission of 11 convicts in Bilkis Bano's case granted by the state government of Gujarat. About remission refers to the reduction in period of sentence imposed on a person without affecting the nature of the sentence. A state may release convicts early under their remission policy. Constitutional provisions related to remission. Article 72 empowers the President of India to grant pardons, reprieves, respite, suspend, remit, or commute the sentence of the person convicted of any offence where the sentence is by court martial for the offence against any law relating to a matter to which executive power of union extends a sentence of death. Under Article 161, governor's power is similar to that of president but limited to a matter to which executive power of the state extends. Governor can suspend, remit, or commute a sentence of death. However, power to grant pardon for the sentence of death lies with the president only. Legal basis of remission. Section 432 of the Code of Criminal Procedure CRPC 1973 grants government power to suspend or remit sentences. Section 433 Capital A 433A mandates remission only after 14 years of imprisonment. Section 473, 475, 476, 477 of the Bharati Nagrik Suraksha Sanhita BNSS 2023 contain provisions related to remission. Judicial pronouncement related to remission. Lakshman Naskar versus Union of India 2000. Supreme Court laid down the 5 grounds on which remission is to be considered. Offense affected society at large, probability of crime being repeated, potential of convict to commit crimes in future, if any purpose of being served by keeping convict in prison, if any purpose is being served by keeping convict in prison, and socio-economic condition of the convict's family. Rajkumar versus State of Haryana 2021. Court held that Section 433A of CRPC cannot and does not in any way affect the constitutional power conferred on President or Governor under Article 72 or Article 161 of the Constitution of India. Other important news. Advocate on Record AOR. A committee headed by the Chief Justice of India designated 56 lawyers and advocate on record AOR as senior advocates, 11 of them women. Supreme Court rules 2013 prescribe eligibility criteria for an AOR advocate on record. AOR advocate on record means an advocate who is entitled under these rules to act as well as to plead for a party in a court. No advocate other than AOR for a party shall appear, plead, and address the court in a matter unless he is instructed by AOR, advocate on record, or permitted by court. Bail. What is the meaning of bail? Recently, the Chief Justice of India (CJI) highlighted that growing reluctance on the part of the trial judges to grant bail is violating rights to personal liberty under Article 21 of the Indian Constitution. Bail means release of a person accused of an offence from the custody of law upon certain conditions imposed by an officer or court, including execution by such persons of a bond or a bail bond. Interim bail, it is granted for a short time before the hearing for the grant of regular bail or anticipatory bail. Regular bail granted to a person who has been arrested or is in police custody. Anticipatory bail, it can be filed by those who fear arrest for a non-bailable offence. Default bail, also known as the compulsive or statutory bail, it is provided under Section 167 Clause 2 of Criminal Procedure Code (CRPC). It affords protection to the accused against detention due to inordinate delays in completion of the investigation and filing of the charge sheet within time frame stipulated by law. Changes under Bharatiya Nagrik Suraksha Sanhita (BNSS). First time offenders will be given bail if denied if detained over one third of the maximum period of imprisonment. The new law has added a stricter provision by denying bail to the under trial prisoners if an investigation, inquiry, or trial in more than one offence or in multiple cases are pending against the person. The new law has made a provision mandating the superintendent of jail to submit an application in writing to the court to proceed to release the under trial prisoner or on bail who has completed one third or one half of the sentence as the case may be prescribed for the offence in the Sanhita. Need for police custody beyond first 15 days not a ground to deny bail. Our next chapter is election, electoral bond scheme and municipal elections, urban local bodies and model code of conduct, other important news about election. Thank you very much.